So if this broad proposition and these rather general categories are correct, what is the connection between the justices' religious background in the sense of the particular strain of Catholicism or Judaism they grew up with, and their likelihood to be supremacists, separationists, and partisans of religious neutrality? The connection may not be able to be traced directly, but broadly, the rise of neutrality and the collapse of support for strict separationism seems to me partly generational, and it has to do with the collapse of separationism among the mainstream religious denominations. It was a surprisingly brief period in which the era of strict separationism reigned. It was from the early 1970s to the late 1980s when strict separationism commanded the support of a majority of Supreme Court justices. During this separationist era, even after prayer disappeared from public schools, as did creches and Christmas hall displays. You all know the joke about the idea that there was the 3 plastic animals rule, that only if there was a reindeer and a Santa Claus could other religious displays be permitted. Religious conservatives complained that the courts had banished religion from American public life and were enforcing a rigid secular ideology. But thanks to a paradigm shift in the courts that religious conservatives have been slow to acknowledge, traditional defenders of church-state separation are increasingly on the defensive legally and politically. The court at times seems on the verge of replacing the principle of strict separation with a different constitutional principle that demands equal treatment for religion, although just when you think that the conservative justices are actually committed to neutrality rather than strict separationism, they dramatically unmask themselves as religious supremacists and prove not to be devoted to upholding vouchers, for example, on the grounds that it's private rather than public choice that determines the destination of the funds, but because they in fact ultimately yearn for an openly religious state. Broadly, it seems to me that the strict separationist Ginsburg and the religious supremacists, Scalia and Thomas, are generational to a large degree. They're both reflecting the presuppositions of the religious traditions they grew up with at the time they grew up there with them, whereas the younger justices, in particular Kagan, grew up at a time when the main conflict was not between separationism and supremacism, but between the secularists and non-secularists. And non-secularists, both Jewish, Catholic, and Protestant, increasingly found they had more in common with each other than they did with the secularists, and realigned as a result. Obviously, to a large degree, the story of how the wall went up and how it came down is in a large measure the story of the relationship between Protestants and Catholics in America. The fall of church-state separationism reflected the realignment of Southern Protestants who used to oppose state aid to religious education, but now support it. By the 80s and 90s, white Southerners were Republican rather than Democratic, and in the wake of the Supreme Court decisions banning school prayer and legalizing abortion, they felt more alarmed by what they perceived as creeping secularism than by the threat that public funds might lead to the growth of the Catholic Church. For the high water mark of the old anti-Catholic Baptist view on the Supreme Court, of course, we need look no further than Justice Hugo Black, the former Alabama senator, Ku Klux Klan member, an enthusiastic anti-papist who announced in 1947 that the First Amendment has erected a wall between church and state. That wall must be kept high and impregnable. We could not approve the slightest breach. Justice Robert Jackson, in dissent, said that he was like the Byron's Rape of the Lock, who exclaimed, and whispering she would ne'er consent, consented, because Black, of course, in the end approved the school funds at issue in the Everson case. But Walter Dellinger, who clerked for Justice Black before becoming acting Solicitor General in the Clinton administration, confirms the connection between Black's separationism and his anti-Catholicism. Dellinger has said that in part, Black was a Bill of Rights absolutist, and in part he was a Southern Baptist who was concerned about the power of the papacy. Protestant suspicion of the Catholic Church may have driven the separationism of the post-war era, but other religious groups contributed too. After World War II, mainstream Jewish organizations like the American Jewish Congress and Anti-Defamation League decided that building a wall of separation between government and religion was the best way of protecting Jews against discrimination. And it was the Thurgood Marshall of strict separationism, Leo Pfeiffer, chief lawyer for the American Jewish Committee's Commission on Law and Social Action, who was an uncompromising secularist who turned his attention to forbidding any public funds to be channeled to faith-based schools and charities. Pfeiffer's greatest victory was the 1971 Lemon case, a benchmark of strict separationism that struck down state laws that provided salary supplements to teachers of secular subjects in Catholic and other federal enterprises. Why did the political, religious, and legal forces that had converged to produce the wall of separation collapse? The most important political development is the privatization of the public sector, as liberals and conservatives lost confidence in the ability of government to provide welfare and education services in the inner city. In the wake of that collapse, many of the groups that had been stalwarts of church-state separationism began to abandon their position. Consumers of education and welfare services in the inner cities, most notably African Americans, grew tired of being told to wait for improvements that never came, and their growing enthusiasm for parochial education among African Americans changed the face of parochial schools, leading them to be less white and blue-collar and Catholic, and leading parochial schools to open their doors to non-Catholic children. And this changing composition of parochial schools contributed to the decision by evangelical Protestants to abandon their traditional opposition to school vouchers. Once it became clear that vouchers wouldn't benefit the Catholic Church at the expense of all denominations, the liberal and evangelical Protestant establishments set their traditional rivalries aside and began to start their own schools. At the same time, there was a realignment among the Jews. Some Jewish neoconservatives concluded they had more in common with evangelicals and the Catholic hierarchy than the pillars of Reform Judaism like B'nai B'rith. As Jews became culturally assimilated, they felt less threatened by an increasingly tolerant Christian majority, and mainstream Christian religions became less sectarian and less threatening to religious minorities. In 1965, my other hero, Tom Lehrer, delivered the following verdict on the state. The fact that you're laughing here is a good generational thing. my fellow boomers can get that reference. Then in that case, you all know the song that I'm about to refer to. His verdict on the state of intersectarian relations in 1965 was, oh, the Catholics hate the Protestants, and the Protestants hate the Catholics, and the Hindus hate the Muslims, and everybody hates the Jews. We know that one well. Thank you. I couldn't possibly do another one. No, that's all right. But 30 years later, we have sects that used to compete over whose vision of revealed truth would triumph in the public sphere began to see value in one another's work. And in an age when everyone is a hyphenated American, religious identity became just one more prefix in the pluralistic mix. Doctrinally, this political and intellectual declining support for strict church-state separationism came at a time when the legal underpinnings were collapsing as well. The revolution was driven by ideas from the legal academy as liberal and conservative law professors began to argue in the 1890s and beyond that equal treatment for religion might be a more appropriate model than strict church-state separationism for protecting religious liberty. I think the shift in the legal culture is best represented by the career of people like Douglas Laycock on the left and Michael McConnell on the right. McConnell, the former judge on the U.S. Court of Appeals for the 10th Circuit, one of the most influential advocates of equal treatment for religion. He describes himself as a theological conservative. He was reared as a Presbyterian. He renewed his faith while clerking for Justice William Brennan, a titan of the Great Society. McConnell's leading victory was the 1995 Rosenberger case, where he had a chance to convince the current Supreme Court that the legal debate had shifted so significantly that strict separationism should be repudiated in favor of equal treatment for religion. Rosenberger involved a university rule at the University of Virginia, which allowed all journals of student opinion, except those with a religious perspective, to receive a subsidy from a student activities fee. Lower courts had said that a university couldn't withhold fees from a gay student newspaper because it disapproved of the message, and McConnell argued that a religious newspaper was entitled to equal treatment. The Supreme Court agreed with McConnell by a 5-4 vote. 4 justices, Rehnquist, Kennedy, Scalia, and Thomas, said the First Amendment forbids public institutions to exclude religious groups from benefits offered to a broad class of participants. That's the religious neutrality position, although it includes some covert supremacists. 4 justices, Souter, Stevens, Ginsburg, and Breyer, made a last-ditch defense of the old separationist principle that the First Amendment prohibits direct government financing of religious activity, even if the funds are distributed as part of a neutral scheme, and Sandra Day O'Connor concurred with the majority but drew some small distinctions that preserved her ability to change her mind in a future case. It is striking, I think, how closely the positions of some of the justices in this church-state case corresponds with their own religious and educational backgrounds. 3 of the 4 most ardent proponents of equal treatment for religion, Scalia, Kennedy, and Thomas, now joined by Roberts and Alito, are practicing Catholics. 2 attended parochial schools. And indeed, the fact that presidents are not uncomfortable with the fact that there are 6 Catholics and 3 Jews on the current court is itself a significant sign of the change in a relationship between religion and government. One test of a group's integration into American society, Walter Dellinger again observed, is the point at which no one thinks the trait in question is a relevant consideration in a Supreme Court nomination. So within a single generation, Catholicism or Judaism, like geographic origin, simply became beside the point. For Republicans, ideology, judicial ideology was far more important than either religion or geography. Democrats have been especially attached to glittering meritocratic resumes and the demands of identity politics, which trumps religion as well. And there's also the fact that Jews have completed the integration process. When Breyer was the second Jew appointed by President Clinton after Ruth Bader Ginsburg, his religion was barely noted. And as I say, Ginsburg retains the separationist instincts of relatively secular Jews born after World War II, but Breyer, with less of a religious background, is more pragmatic in religion cases. What will the future bring? I am interested to see the clash between neutrality and supremacism. And I do think that Scalia and Thomas, and we'll see about Roberts and Alito, are really more committed to supremacism than neutrality. For them, neutrality is just a strategic stopgap on the road toward their broader goal of an openly religious state. Among the liberals, Ginsburg is a firmly committed separationist. Breyer, Kagan, and Sotomayor also have to choose, just as the conservatives do. Are they going to remain committed to strict separationism as a strategic matter? And their vote in the Arizona tax credit case suggests a lingering attachment to some of the old separationist analysis, or do they believe that they can peel off a conservative justice or two and avoid open endorsement of supremacism by compromising around religious neutrality? And Justices Kagan and Breyer's willingness to compromise with Chief Justice Roberts in the riveting and important healthcare case last term suggests that unlike Justices Ginsburg and Sotomayor, who in that case refused to make a deal on the question of the voluntary nature of the Medicaid expansion, Breyer and Kagan are committed to winning over and working with Roberts and Kennedy and might use religious neutrality as a means for doing so. Regardless of its fate before the Supreme Court, I do think that the rise of religious neutrality represents what Alan Brinkley, the Columbia historian, has called a more typical relationship between religion and the public sphere if you look over the span of American history. Americans have always been deeply religious and deeply suspicious of state-imposed uniformity, and in an age when religious identity now competes with race, sex, and ethnicity as a central aspect of how Americans define themselves, it almost seems like discrimination, the only unforgivable sin in a multicultural age, to forbid people to express their religious belief in an increasingly fractured public sphere. In that sense, the new vision of equal treatment for religion might be seen as a return to a more normal vision of separationism, which insists that religious activity should be initiated and controlled by individuals rather than the state. In this sense, the decline of the wall of strict separation doesn't represent a radical new intrusion of religion into public life, but instead a loosening of rather recent boundaries that in the minds of some people might themselves be seen as an innovation. And as for the religion of justices, we can see that it doesn't determine judicial philosophy, but it may in fact influence it. Those are my tentative thoughts on this difficult subject, and I would love to have a conversation with you about it. Thank you so much.